Good afternoon, Advocate Sibisi.
Sibisi. Good afternoon, CJ.
Are you well?
I'm fine, thank you. How are you?
Good. May we start?
Yes, we can start.
All right. Oh, there it is. You obtained an LLB degree from the University of Natal, from my alma mater, the University
Yes.
of Natal in Devon,
That's
in
correct,
2000.
That's
in
correct.
2000. All right. And you did your articles at Nhlanhla Mnulwane Incorporated.
Yes, that's correct, CJ.
But then you didn't stay long there. What happened, if I may ask?
My articles I started at Nhlanhla Mnulwane Incorporated, and after just over 6 months, they were ceded to another law firm.
All right. And then they made you associate, and you moved on to another firm and another firm until you started your own practice.
That's correct, CJ.
And that was in 2008 now. But then you didn't stay long in that practice.
Yes,
You decided to become an advocate.
that's correct, CJ.
All right. And you have practiced as such since 2011.
Yes.
Okay. What kind of a practice do you have? What kind of
CJ?
work do you do?
I have a varied practice.
I'm sorry, just draw the mic closer to you.
Yes, thank you. I have a varied practice, but I deal mostly with personal injury law. I also have commercial work. But as I indicated, it's a varied practice, but I mostly deal with the two areas of law that I've mentioned.
And you have acted as a judge
That's correct.
on a few occasions.
I beg your pardon, CJ?
You have acted as a judge on a few occasions.
Yes.
When exactly and where?
I started in 2023. I've had 9 stints. Yes.
Coming up to how long?
According to my calculations, it's 33 weeks.
All right. In the same division.
In the same division, but in both centers, Pietermaritzburg
and
and
Durban.
Durban.
And you have sat in all the courts?
Yes, that's correct.
Right. Written judgments, I see.
Yes, I have written judgments as well.
Any of them reported?
They have not been reported.
Not yet. How many would you say you've written so far?
51 written judgments.
And not even one reported?
I've tried, CJ, but it hasn't been.
It's not up to you, is it?
I've only sent them to Safely, and they've only been.
But they are available on Safely, I would imagine.
Some of them, yes.
Okay. I think I should stop here and allow Judge President Boyodlo to put you through the ropes.
Thank you, CJ. Good afternoon, Advocate Sibisi.
Good afternoon, JP.
You've acted both in Pietermaritzburg and in Durban. How have you found the colleagues?
The colleagues have been good, very helpful. I've learned a lot from them. I would say all the colleagues that I've worked with have made a difference in my life and made the transition easy.
Yes. And I assume you've had an opportunity to sit in full court and in full bench appeals.
That's correct, JP.
Yes. And in those, you've scribed some judgments.
That's correct.
And how was the feedback from the presiders with your judgments?
I've received good feedback. And in most of them, I've volunteered to be the scribe.
Yes.
There were few areas I had to revisit in my draft judgments, but overall, the feedback that I got was good.
Yes. And I see that you sit as a chairperson of the tax board,
That's correct.
and you also write judgments there, I would assume.
Yes, I've written numerous judgments there as well.
And have any of them been taken on review?
Not that I'm aware of. I've never been notified
Yes.
of that.
And in the High Court, you have, as you have said, about 51 written judgments. What is the longest you've taken in handing down a judgment?
JP, unfortunately, there were about 2 matters where I took 5 months to deliver judgment.
Yes.
In circumstances where I had the matters towards the end of my acting stints and having to go back to my practice, so there were, I'll say, conflicting interest in that I had to maintain my practice, generate an income, but those are the 2 judgments that I'm aware of. It's 2 judgments that I'm not proud of because of
Yes.
the time that it took to deliver them.
Yes, I recall that I think I received 2 letters or so where the litigants were asking me to nudge you about those judgments.
Yes.
And what is the status of them now?
I've delivered all my outstanding judgments.
So as you sit there today, there are no outstanding
I
judgments?
have nothing.
Yes. I'll come back to that because I had asked my office to just update me because I saw the comments from the SHCB and other professional bodies. So I would want to just verify with you if there is anything negative. So coming back to the questions that I have, in the criminal matters, how many stints did you have? How many weeks were you able to do criminal matters?
I have the first one, the very first acting stint I had, I did crime. So it was about 5 weeks. So I completed a trial, a full trial, and there were some matters, guilty pleas, plea bargains that I dealt with. And then the last one, which ended on the 20th of September, the matter became parted for a variety of reasons. We couldn't proceed, including the attorney being sick, the accused being sick, and the withdrawal of one of the attorneys as well.
Yes.
Yes.
So you have one criminal matter that you finalized?
Yes, one trial that I
One
finalized.
trial.
Yes.
Yes. All right. So just one question on the criminal matters. Your understanding of Section 105, capital A of the Criminal Procedure Act, the plea bargaining.
Yes.
What are the considerations that a judge should have in accepting that plea?
JP, the judge should have a look at the agreement that the parties reached, so far as the conviction and the sentence are concerned. But if the presiding officer thinks that the sentence is not appropriate, then the presiding officer can reject the agreement in terms of Section 105.
Yes. And if a complainant or the families have not been consulted, what is it that you can do as a presiding officer?
Is to perhaps afford the family a chance to comment on the agreement between the accused and the state.
Yes.
Yes.
And just on the appeals, if a matter comes before the full bench, so that will be a decision of a magistrate before you, and the appeal is only in respect of sentence,
Yes.
but you are not satisfied about the conviction, what is it that you can do as a judge in order to deal with that issue? Must I repeat, or you are thinking about it?
I'm thinking about it
Yes.
because I've never encountered such a situation before.
Yes.
Um,
So if the person was convicted and
yes,
they come before you
yes.
for sentence only, but you're not satisfied about the conviction.
I'm thinking off the cuff, JP. I would afford both parties a chance to address me on an issue that I'll be pointing out. If it means that I cannot deal with the matter rather than I can perhaps have the matter adjourned so that I can afford them a chance to deal with that. But I'm not too sure of my answers.
Yes, because I would imagine if there was no leave to appeal from the
Yes.
magistrate's court, would you be able to deal with it in the High Court?
I don't see how I can deal with it
Yeah.
because it was not dealt with on those bases.
Yeah.
Yes.
Thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you, CJ. I have no question.
Professor Barumahai?
Thank you very much, CJ. Good morning. Oh, afternoon, I beg your
Good
pardon.
afternoon,
I mean this,
Commissioner.
Would it be a fair assessment that your strength is in criminal law?
It wouldn't be a fair assessment because I've not been exposed as much as I have been in the other areas of law. But I certainly have.
Which area of law would be your strength?
I'll say in the field of personal injury law.
Or personal injury law?
Yes.
Oh,
But then at the same time, I started off in a firm that does criminal work. And from time to time, I've handled criminal matters. So I'm familiar with it.
oh, okay. Let me ask you a question nonetheless in criminal law. When one looks at the Criminal Procedure Act and you look at the schedules, different schedules, one would immediately realize that there is a duplication of offenses in various schedules. And sometimes it's not necessarily easy to determine which schedule is applicable in a particular matter. Because you'll see various crimes appearing on various schedules. But there are certain tests that are used for you to determine whether this is Schedule 1, Schedule 2, Schedule 5, and Schedule 6. I'm more interested in Schedule 6 offenses. What generally renders a particular offense to be regarded as a Schedule 6 offense? And what is the test that ought to be satisfied by the accused if they want to be released on bail?
Yes. I'll say that to answer the first part of your question, what determines categorizing a crime to fall under Schedule 6, I'll say it's seriousness of the offense. And then you asked me about the requirements for bail. It has to be exceptional circumstances have to be satisfied, which in the interest of justice supports the bail application in favor of the applicant.
Thank you very much. Thank you, CJ.
Commissioner Mangai?
Thank you, Chief Justice. Good afternoon, Advocate Sibisi.
Good afternoon, Commissioner.
Yes. In the matter of Ahir, Ahir versus Govender.
Yes.
Ms. Govender was apparently an unrepresented litigant.
Yes.
And when the matter came before you, she applied for a postponement and you refused it.
Yes, correct.
But reading the judgment, I am not able to find the basis upon which the request for a postponement. Why did you postpone? Did you refuse the request?
I had two reasons for that, Commissioner. The first one is that the matter was not initially allocated to me. It came before a different judge. She tried, in fact, she moved an application for a postponement before that judge, and it was refused. And then on the same day, when the matter was allocated to me after the recusal of the first judge, she applied for an adjournment again, but then did not elaborate on the reasons. Was in support of her application, other than saying that she's not represented. And it is this particular litigant also had applied in the past, previously, in the past for a postponement, which she got. So I didn't find sufficient reason to grant the postponement solely because she was not represented. I found the reasons were just not sufficient for me to grant, at least the ones that she was presented to me.
As I read the judgment,
Yes.
the first request for a postponement was because the acting judge then came from the same bar with the counsel for the plaintiff, and the judge then recused himself on that basis. So the second time, when she made a request for a postponement, she said that she's not able to deal with the matter. And then you refuse the postponement. You are not explaining why you are refusing the postponement, nor are you offering any assistance to her in the form of either referring her to legal aid and or asking the bar counsel to make a counsel available to assist her.
Okay. The point that that came when the first judge was dealing with the matter, that the acting judge was from the same group of advocates and as the plaintiff's counsel. That was the reason for the recusal, not for the postponement. And without repeating myself insofar as the postponement is concerned, Commissioner, I just felt as if the reasons that were advanced by her were not sufficient to warrant a postponement of a trial. So would have effectively meant that the trial was going to be postponed, if I'm not mistaken, for the third time. And I didn't get the impression that she was going to be prejudiced because she seemed to understand the factual issues that she had to deal with because she was, she created to me that impression that she was able to deal with the matter on her own.
Thank you, Advocate Sibisi. Thank you, Chief Justice.
Yeah, thank you. Thank you. Good afternoon, Mr. Sibisi.
Good afternoon, Commissioner.
Yes, just as a follow-up, but perhaps then to rather raise it as a question of general principle. What are the factors that you would take into account, a judge takes into account when confronted with a request for a postponement? And did you consider those factors in this specific case that you were discussing?
Commissioner, I would say I considered what I considered. I considered what I thought was important in the circumstances that I looked at the reasons for the postponement, and it did not seem as if there was something new to what the applicant was raising, that is the defendant in the matter. I didn't get the impression that the postponement was going to serve any purpose. That is perhaps obtaining legal representation, because the matter had a long history. There were attorneys at some point that were involved. I think they were changed at some point, but I stand under correction. The matter had a long history, and those postponements that are spoke about, but it's she certainly did not support that case for warranting a postponement of a trial, in my view.
I was trying to move it away from this specific case, just to
Yes.
speak to
Yes.
what are the factors ordinarily that you would take into account. Forget the facts of this case.
Yeah, I'll consider questions like prejudice, for example, if the postponement is not granted, and perhaps deal with the question of cost then. But in this, as I indicated, without repeating what I've already said as well, that that's the main thing that I will look at, the question of prejudice.
Would you consider prejudice to the other as well?
Yes,
Or
yes,
just
yes.
consider the
Both parties.
Thank you.
Thank you.
Commissioner King?
Thank you, CJ. This is a follow-up question. Good afternoon.
Good afternoon.
You've been asked two questions, one by the JP, if I recall correctly, and one by my fellow commissioner, relating to something that arises in your court, a criminal appeal where you sense an injustice has been done on the merits, a question of a postponement and how you deal with the issue. And this is obviously not an exam. We're expected to know everything off by heart. But when something like that arises, how would you find the correct answer? Where would you turn? How would you go about approaching something that arises where you don't immediately know the answer?
Yes, what I normally do, I normally do my own research, and if I still don't get the answer, then consult colleagues who might have dealt with the same point. So I wouldn't I wouldn't leave it at that, but I will certainly consult with senior colleagues.
Thank you.
Anyone else? All right. This is the end of the interview, Advocate Sibisi.
Thank you, Chief
You're
Justice.
excused.
Thank you, Chief Justice.